First case is Licitri versus DiBaggio, and I'll just go over a few ground rules with you real quick. This is being recorded. Each side will have 15 minutes, and the appellant may reserve up to 5 minutes. However, we have to always be careful. We want to make sure that we tell everybody, whether it may be relevant or not, that if there's a minor involved, we don't refer to the child by name. We refer to them as the child or initials. The victim, in any case, we don't refer to them by name. We call them either the victim or the neighbor, or however you want to refer to them, or by initials. But we try not to ever use the names because, as we all know, now with things being recorded, it's on there forever. So it'll always be accessible to people. And then finally, stand behind the lectern, obviously, and keep this, please stand only there because that way we record you and keep your voices up. And otherwise, I think that's about it then. And you can tell me how many minutes you'd like to reserve, if any.
5.
Okay, sounds good, thank you. Oh, and the monitor over there gives you your time as well. And I will try to alert you if you're getting into your 5 minutes, but, okay? All right, you may proceed.
May it please the court, I am Joseph J. Licitri, the plaintiff appellate in the case before you. It is well understood that a party who files summary judgment bears the burden of proving no material facts are at issue. The facts, however, are to be construed in the light most favorable to the non-moving party in summary judgment decision. I do understand that the courts generally disfavor summary judgment in negligence cases. The case before you is the defendant is appellee in this case. They have created a case in the record that does not exist by changing material facts that are well established in the record and developing a strategy based upon a false premise. In the case before the court, it's easy to recognize what the defense in cooperation with the trial judge has produced. Instead of dealing with the complete record, the facts, the laws, case law, they have created a case that doesn't exist. This was the legal sleight of hand strategy that gave the defense something that they could argue regardless of the veracity. The trial court demonstrated a complete lack of understanding of the case before it. The real facts in this case give the defendant nothing to argue. This case is simply, did DiBaggio act within the law when he sent an enforcement letter dated October 4th, 2021. It was entitled a notice to cure. It was an enforcement letter as indicated that Licitri was responsible for the legal fees as the law requires owners to pay legal fees for enforcement. It was not a notice of violation as described by the defendant and the trial court who took the bait on that issue, which was completely a false representation. Since there was never a notice of violation and never an offer of hearing, as the law demands in Ohio Revised Code 53-11-081, Section C, since there was never an offer of hearing on his October 4th letter, it could not possibly, there could not possibly be any enforcement of any decision except in DiBaggio's imagination, because there was none. Now, look, as of the October 4th letter, he may have been incompetent, and I think there's lots of reasons why he is incompetent. And I can point that out also as we go. But when I responded how he acted outside the law on October 14th, no longer was there just a mistake, didn't understand it, I did this, I thought, no. At that point, no, it was doubling down. Now, he asked in his letter, do you have anything concerns, please let me know and all that. And I did let him know with that October 14th letter. How many times did he contact me? How about 0? He didn't contact me at all. He acted completely in bad faith the entire way. Now, bad faith is a fact in dispute. That is a jury question. It's not a question for a judge who really has no interest in this case, and I can get onto why she let me believe that by the statements she made in open court. But I will tell you that now, the letter misrepresents the law, and it was designed for me to fall in line with his unlawful action And it was designed to encourage the board to continue, as they continued and continued and continued, based on the fraudulent position that he took. I wrote letters to them in October of 21. December, I wrote a letter and a solution to try to settle this case. I wrote to them talking about the law again in January, again in February. What did I get? I got crickets. I got crickets from the association. I got crickets, and even in the original notice of the original hearing in June 4th, which no action was taken, 4 of the remaining board members in that meeting, 2 of them agreed with me because of the evidence I produced, okay, about what had happened in this association. And I tell you, there's more to the law than just, oh, this declaration says this, we have to obey this. Okay? No, there's more to it than that. And you know, there's a hierarchy of law. I'm sure all judges and lawyers should know this. The United States Constitution, federal statutes, case law, federal case law, we've got state constitution, and so on. You know what's at the bottom? Rules of the kind of association. Bylaws. Declarations. It even says in the Cayman-Cusimano legal handbook. Okay, so consequently, we need to look at what controlling law. For example, if they said you cannot sell to an African American, I sell my unit to an African American, and they sue me in court. Well, first of all, the Declaration says this. It doesn't matter. It doesn't matter what the Declaration says. What matters is what law controls this. And I'll get into that hopefully about the controlling law. So let's see. Okay, here's a quote from the website, admitting privity to me as an owner. Listen to this quote from the Cayman and Cusimano. Our attorneys are skilled at navigating the delicate enforcement process, which preserves an association's ability to enforce its restrictions and affords owners an opportunity to cure any violations. I got no opportunity, by the way, no opportunity. Enforcing deed restrictions and rules is one of the most difficult tasks an association is called upon to perform. But our experience has shown that a proper enforcement process strengthens the community, and get this, and provides its owners with the protection they expect and deserve as members of the association. What protection did I get? He violates the law, violates fundamental due process, he violates. Oh, that was really good. All right. Let's look at some of the elements here, because fraud is clearly established by the letter. He's pretending to, he misrepresents the law blatantly. There's no doubt, that's not a question. And that is fraud. That's misrepresentation. It meets all the elements of fraud. They labeled the June 4th thing as a meeting. Well, it was a hearing. It's alluded to both ways in my amended complaint, so I didn't consistently describe that. But you know, the law is confirmed by the case cited Country Club Condo Association versus Salmon. Exactly the same fact pattern. Making an assessment, charging an assessment, in that case it was $16,000, for something he had no notice of. Guess who the law firm was? My goodness gracious, it was Cayman and Cusimano, arguing the case at the trial court. It was simple. He was charged for an assessment that was never made. He went to court, sued the association. There was no trial necessary. It was plain simple facts. Everybody agreed on them. Cayman and Cusimano argued that they had the right to do that. I mean, this is ridiculous. And these are professionals in condo law. So they come to the Court of Appeals. What did the Court of Appeals say? No. The Court of Appeals in reviewing the case says 5311.081 is mandatory. It's not if you decide to use it or if you decide to self-style your own enforcement or decisions. It's not for that. It's not a luxury. Well, we'll pass out due process if we feel like it. That is absolutely important to the basis of our legal system.
But the case in front of us today doesn't involve the condo association. It involves the attorney.
Right, who represented the condo association. That's my point. Okay, he should know better. He doesn't know better. I'm sorry he doesn't, but you know. Now, they cite, oh, there's no record in his letter of me getting permission. You know, I went to the association and I said, I want to see the records. I was here since 1999, and he says he says he couldn't find any records. Guess what? out of 47 years of records. They're each in a box. I want the records from 1999 when I moved in there. Guess what's missing? There's no records from 1999. And what is more remarkable is when I asked, before we went up to check where the records were, the board member said, oh, we don't have that. Well, I said, how? We don't have that? How would you know in advance that you don't have a 1 year out of 47? Oh, do you think I'm stupid? What does that mean? That's the response I said, I don't think it has anything to do with intelligence. I just want to know how you knew in advance that you didn't have that. Now that is suspicion. That needs to go to a jury as far as credibility goes. He claims that, oh, we looked at records. You know, there's a good chance that you're not going to find what you're not looking for. You could find it. Blind squirrel finds an acorn. We understand that. But to claim that you did that, no. Okay, I've got 30 seconds here, Joe. Okay, now we go into bad faith. The letter inviting a response from me, and then we've got no response for 4 months of me sending letters and making claims. And then one of the board members at the meeting resigned, and there was a fifth board member who came on. She was not at the hearing. She knew nothing about the case. I made an appointment to meet with her, just to give her information. I said, I can argue with you, just give you information. She made the appointment with me, and an hour before the appointment, before I could give her information on the case, what happened? Oh, she talked to the lawyer, and the lawyer said, you don't meet with him. Okay, that's bad faith.
Thank you. You have the remaining time for rebuttal.
Good morning. My name is Maya Jaron, and I represent the appellee Joseph DiBaggio. And I respectfully request the court affirm dismissal of Mr. Licitri's claims on summary judgment. So I'll give you a very brief background of the salient facts here before the court. Mr. Licitri owned a unit in the Independence Place South Condominium Association. Attorney DiBaggio at all times represented the association and was their legal counsel. So a dispute arose at some point about whether Mr. Licitri could operate a piano business from his unit. That's certainly disputed whether he could or couldn't. But what isn't disputed is that Mr. DiBaggio sent a letter to Mr. Licitri on behalf of the association saying, please stop your piano business. Mr. Licitri, of course, disagreed with that letter, but that is the sum and substance of Mr. DiBaggio's involvement in conduct here. He sent a letter on behalf of his client, the association, to Mr. Licitri. And as a result of that, Mr. Licitri filed 2 lawsuits. He first sued the board members individually of the association. Those claims have been voluntarily dismissed. In a second lawsuit, he sued the property manager and then, of course, legal counsel, Mr. DiBaggio. The claim against the property manager has also likewise been voluntarily dismissed. So the only claim then for summary judgment was the claim against Mr. DiBaggio. And those 2 claims they're not fraud. He didn't plead fraud, as he just mentioned in oral argument. The claims before the court were gross negligence and intentional infliction of emotional distress. And so Mr. Licitri did not conduct any discovery. Mr. DiBaggio filed a motion for summary judgment, which was granted, and that should be affirmed. Now 2 assignments of error were raised here. The first pertains to a default judgment. Mr. Licitri didn't refer to that here. I'll stand on my brief with respect to that argument, just to say that there is no such thing as a sua sponte default judgment, nor did Mr. Licitri move for default judgment. And by filing an amended complaint, the whole issue is entirely moot. And then turning then to the summary judgment, there are a number of legal reasons that the court properly granted summary judgment. As a threshold matter, Mr. Licitri's opposition didn't point to any Rule 56 evidence, which the court noted. So just on that matter alone, the judgment should be affirmed. But turning to the substance of the malpractice claim, and really what is before the court today is a malpractice claim, because any claim arising from the representation of a client must be construed as malpractice. And that's Illinois National Insurance versus Wiles, Boyles, Burkholder, and Brink Gardner, and all the cases that were then cited in our brief, and that's standard Ohio law.
Let me ask you this, counsel. I understand your argument about the malpractice, but I'm trying to figure out where a cause of action for intentional infliction of emotional distress fits into that. Are you suggesting that an intentional infliction of emotional distress is automatically malpractice anytime an attorney is sued?
So a claim, no matter what it's called, if it arises from the representation of a client, must be construed as malpractice. Now, what the intentional infliction of emotional distress claim kind of does is invoke that one of the exceptions to strict privity. There are 3 exceptions, only one is relevant here, it's malice or bad faith. So Mr. Licitri has not presented any evidence that Mr. DiBaggio, by sending a single letter, acted with malice. And in the legal malpractice context, malice is a little bit different. Malice has to be either extrajudicial activity or acting in not in his client's best interest. So neither of those apply.
Let me interrupt you for a second, because I think your argument to begin with, though, is he was not his client. There's no
Correct.
relationship.
Yes, I'm getting
So
there.
wouldn't that interfere, wouldn't that be different than in analyzing the intentional infliction of emotional distress for somebody that is not a client of the attorney?
Well, the key here is that the association was Mr. DiBaggio's client, and at all times relevant to this lawsuit, Mr. DiBaggio acted on behalf of his client. So there is no extrajudicial activity because the letter was sent clearly on behalf of the association.
But that's my point. How do you analyze it? Because you seem to be analyzing the intentional infliction of emotional distress from the viewpoint of an attorney-client relationship. And I'm saying, but your argument is there's no attorney-client relationship. So how do you use that to countermand or try to analyze a relationship that doesn't exist in terms of intentional infliction of emotional distress?
Well, the attorney-client relationship that's key to this case is the one between Mr. DiBaggio and his client, the association. That's what puts us into the realm of malpractice. But even outside that, assuming that the claim is not subsumed into malpractice, for the sake of argument, it doesn't matter. The claim should still have been dismissed for a number of reasons. Of course.
So what did Mr., and I apologize for messing up the name to begin with, what did Attorney DiBaggio submit in summary judgment?
He submitted a number of things, but the most important to bring up today is his declaration. On this issue of the standard of care, of course, he presented expert testimony, which he's permitted to do. He did not violate the standard of care, he did not act maliciously, and at all times acted within the scope of his representation of the association. But even absent that, Mr. Licitri failed to offer any evidence that Mr. DiBaggio acted with malice. There is certainly a threshold for malice, outrageous, extreme conduct.
Did he allege that in his complaint?
He alleged it, and that he did, yes, it was alleged, but there's no evidence. And then at the summary judgment level, of course, sending a single letter, as a matter of law, does not rise to the level of intentional infliction of emotional distress. But aside from that, you also need to establish severe medical issues. And Mr. DiBaggio did not do that.
I understand. I guess I'm just trying to, and we'll be looking at the record, but so Mr. DiBaggio had an affidavit
Did.
and then an expert witness.
He was his own expert witness, which was permitted under.
I could remember that. I apologize. Yes, I do remember that now. Okay, so he presented an affidavit and said he acted within the duty of care and didn't actually have his own client anyway, right?
Correct, but again, the attorney-client relationship that's important here is that Mr. DiBaggio represented his client. It should be construed as malpractice, even if it wasn't construed as malpractice, as we're suggesting here. The legal elements of the claim for intentional infliction of emotional distress were not met here.
Okay, so what did he say about the emotional distress? He just said all I do is send a letter in the affidavit?
The only conduct alleged on behalf of my client, Mr. DiBaggio, is that he sent a letter.
Okay, and your client replied in the affidavit, I sent a letter on behalf of the association, that's my only contact with him.
Well, the letter exists, it's in the record, so it's not been disputed that Mr. DiBaggio sent
I know,
a
but I'm
letter.
just asking what the attorney said in the affidavit.
I don't believe the letter was
Addressed?
because it is, and it's not disputed that it was sent.
Because you know, the first burden is on the person moving for summary judgment. So that has to be established before he even has a burden to respond with anything.
Correct, and the trial court noted that Mr. DiBaggio had met his burden, and so Mr. Licitri then failed to meet his reciprocal burden, A, by producing any Rule 56 evidence, and B, by presenting any expert testimony on the issue of standard of care or his medical, that he had any medical issues arising from the letter that was sent by Mr. DiBaggio.
Thank you.
And if there are no further questions, I'm happy to answer any more, but I believe I'll conclude my time here.
Thank you. You will have the 454 for rebuttal.
Okay, there's a lot to talk about here. First of all, if anybody knows how to make a valid affidavit, that affidavit is not one. You can only testify to your firsthand experience. I reference these documents, and at all times, I acted at the standard of care. That's self-serving. That wouldn't even be admissible in court as him being a witness for himself. That's not admissible. You can't give opinion. He's declared a self-proclaimed expert? No, I don't believe that.
Well, attorneys do that all the time.
Right, but he wasn't declared an expert to me. Okay, so anyway, now, does sworn documents verified under penalty of perjury constitute a sworn declaration? Yes, it does. Yes, it does. The form of it doesn't matter. And if you look at my motion in opposition, not only did I swear that what I said was true and effective, and of course I'm subject to Civil Rule 11 and the sworn declaration, and I incorporated the entire record in my opposition. The entire record was there. That's what the judge was supposed to consider. This judge had no idea what this case is about. Let me look at some of her statements here. She talks about being a piano teacher. This case has nothing to do with being a piano. This has to do with an alleged violation. It could be painting my garage door red, playing loud music or whatever it is. It could be that, but it wasn't. The allegation has nothing to do with this. There was a hearing, and then she says she bought the Kool-Aid here, saying this was that this letter was just a notice. No, it wasn't. It was an enforcement letter that demanded legal fees be paid. You know, in Ohio law, if you have a scheme of deception, threat, and intimidation to steal something from another person, that's theft. If your scheme fails, it's still theft. In January of 2022, I sent a letter outlining all of those causes of action to the law firm and to DiBaggio. What did I get? Same thing, nothing. I got nothing. These people didn't answer anything.
Mr. Licitri,
Yeah.
are you saying that anytime an attorney sends out an enforcement letter that is illegal and
No,
an intentional?
I'm not saying that.
infliction of
I'm
emotional
saying-
stress?
I'm saying when an attorney sends out a fraudulent letter and he acts in bad faith, the strict privity rule is no longer applied. It's case law. It's in there. It's even in her case law that she said absence, fraud, and absence. No, there's no absence of fraud. That's the point here. Even more than that, this is a fact in dispute. This is a jury question. It's not a question for a judge who doesn't want this case, as indicated by her demeanor in the August 22nd. She wanted me out of there. She said, "You got your money. You need to drop your case." I said, "No." She said, they asked the Attorney General, "Could you guys settle?" They said, "No." And then she starts spouting out how you have to have expert witnesses. No, I don't. Evidence Rule 701 and 702. Read the footnotes in 702 in the Ohio Evidence Rules. No, it clearly says if you have expert testimony that is not needed, that the common person can understand, it's inadmissible. Okay, so there's no expert witness, number one. Number two, does testimony mean anything? A person describing their life and what this letter threatened immediately to destroy an entire career. Now, did anybody hear of courts applying equity principles? Did anybody ever hear that? These are courts of law and equity in Ohio. And no, where's latches? Where's latches? Where's acquiescence? And then, how about if we apply, since he's supposed to, according to our website, look after my fairness too, where's the state, I cited the case, Pineview case, where they talk about the three prongs of reasonableness. The condo, there's evidence they fail in every one of those, and it's in my amended complaint, and it's in the record. She ignored everything, because you know what? She's a very busy judge, and she wants me no part of her business, period. It was so evident. This is not a valid summary judgment case. She needs to look at the entire record. Evidence Rule 702, she claimed in open court that you can't have lay witness. Well, I was helping in cases years ago against an attorney, and we prepared for no expert witness, and we prepared our statement against it, and Judge Bond in Summit County Complex Court, she ruled twice during the trial, this case has to go on because the malpractice was so obvious, anybody can understand it. I'm over.
Well, thank you for being so conscious of your time. I appreciate we all appreciate everyone's argument here, and we will take the matter under advisement, as I explained to you. We will conference, Judge Stevenson will take the time to get brought up to date with everything and feel comfortable with it, and then we will conference and make a decision. It will be a written decision that will be sent to both sides, as well as posted on the Ohio Supreme Court website. Thank you very much.